couple of questions this morning before we get started. You remain under oath from a couple of days ago. Let me again ask you those same questions I've been asking you the last couple of days. Are you under the influence of any drugs, alcohol, narcotics, or medication?
No, Your Honor.
Do you suffer from any mental illness?
No, Your Honor.
Do you understand everything going on here today?
I do, Your Honor.
All right, your lawyer has indicated to me that after consultation with your lawyers, you've made the decision to not testify in this case. Is that correct?
Based off the recommendation, yes, sir.
Okay, you understand it's your decision, it's not that of your lawyers. Is it your decision to not take the witness stand in this case?
That is correct.
All right, and do you understand that you have the absolute right to take the witness stand and testify in this case if you wanted to do so, just as you have the absolute right to not testify in this
Absolutely.
case? All right, have you had enough time to consult with your lawyers about this?
Yes, Your Honor.
All right, do you need any additional time to consult with your lawyers on this issue?
No, Your Honor.
Okay, and are you comfortable and satisfied with the advice that your lawyers gave you with regards to your decision to not testify in this case?
As comfortable as one can be.
What does that mean?
This is what. Yes, yes, Your Honor.
Okay, so you're satisfied with the advice that your lawyers gave you with regards to the issue of and your decision to not testify in this case?
Yes, Your Honor.
All right, we'll go ahead and find that Mr. Colley has freely, voluntarily, and intelligently waived his right to testify in this case. He is competent, coherent, and alert based upon my observations of him, and he did make this decision knowingly and freely after ample opportunity to consult with his lawyers and indicated that he does not desire any additional time to speak with his lawyers. All right, let's talk about jury instructions. I did at about 6 o'clock this morning received the state's version after you forwarded it. My judicial assistant, she forwarded it to me. But that's fine. I understand there was a lot of work involved, and I just got through reading them. I know that Mr. Wood had some edits. I didn't get a chance to read through your edits because I just got your email a few moments ago. We're having some email issues, as usual, in my office. But going through it, I noticed a few things as well. So those may be the same issues that Mr. Wood had, maybe not. Let's go ahead and go through them if you all want to go ahead and bring up your instructions, and I'll bring them up electronically as well so I can make any edits along the way. I think any edits at this point will be relatively minor, hopefully. Thankfully, we're down to about 42 pages now instead of 60-something that we were at before, so our diligent work yesterday afternoon paid off.
Judge, would you like me to state on the record the edits that I thought maybe that might help?
Yeah, why don't you do that and start page by page, and I'll tell you if there's anything before that I picked up on.
Where I jumped in with was on page 10.
The first one I spotted was on page 1, so
Wow,
let's start
okay.
with that.
Wow, okay.
Right under introduction of homicide, second paragraph, third-degree murder, should say third-degree felony murder to be consistent with everywhere else in the instructions, correct?
Yes, sir.
Okay, I'm going to go ahead and make that change on my electronic version here.
Okay.
If I can make these edits, then I can save the state and run back and do it.
Hopefully I caught all these. I was doing a lot of going back and forth as I remember things.
Did you catch that one? Did you catch that last one?
No, I just, you know, wherever it says, you know, these lesser included offenses for this crime, I was kind of doing a lot of back and forth as I remember the things that need to be added, so hopefully I caught everything.
I guess catching that last one makes up for you pointing out my lack of periods in certain spots in the last case that we tried to
We
get.
got some better.
It's a little bit of a sore subject. All right.
I didn't realize how sore, Judge.
All right, Mr. Wood, you said the first one you noticed that was on page 10.
On page 10, there's a duplicative definition of firearm.
Yeah.
Okay.
And I just had lined through that and said that to Mr. Johnson. And then, Judge, the remainder.
Let me change that one. Because I know, I have Mr. Johnson's latest version on my screen. Might be better off bringing up your version, but I'll just work off of this one. And I'll take the definition of firearm out. That's done. What's the next one you spotted, Mr. Wood?
The next one goes to page 22, and all the remaining ones are the juniors that need to be added.
Okay.
So if you'll see on the second on the bottom line, under carrying, concealed, carrying a firearm or a weapon, junior.
Okay. Before you get to page 22, I spotted something on page 17 of, it's count 3. Introduction to homicide. Let me get there.
This is where you asked me to try to merge that.
Right. It's just one word.
Yeah.
In the first paragraph, it currently reads, in counts 3 and 4 of the indictment, James Terry Colley Jr. is accused respectively of the first-degree murder, should read attempted first-degree murder, correct?
Yes.
Everybody agree? All right, so I cut you off, Mr. Wood. What's the one?
No, I was looking at this about 10 o'clock last night, so.
It's a collective effort.
Good. Yes, on page 22, the junior there should be inserted on carrying a firearm or weapon.
Where is that?
On the bottom.
Down the bottom. Underneath carrying a firearm or weapon heading, if you find James Terry Colley, junior should get
I'm looking for that. Maybe,
Under attempted manslaughter. by
Get cut off maybe.
attempted manslaughter? I have juniors where I'm looking.
The next one where it says carrying a firearm or weapon. Very first.
Should be at
Okay,
the,
that's page 23.
oh, okay.
That's why I was struggling with
Um,
that. Pages aren't lining up, so that's,
Okay.
correct that.
And then likewise.
Hang on, I'm not that fast.
Sorry.
When it comes to
I've
typing.
had my coffee this morning.
It's a good thing. Okay.
Next one, same issue on my page 32, it'd be, again, right underneath the heading carrying a firearm or weapon. Got a junior there.
I did on my 32 as well, so bear with me for a moment. Got it.
I thought there were, I printed this out. There it is, thank you. Page 35, this should be the first full paragraph. There's a junior that needs to be added in there.
Where's that one?
If you find James Terry Colley Jr. guilty of burglary, that paragraph, and the second James Terry Colley in there, it does need a junior in there, and I've taken care of that. Are you ready yet?
I thought I had four, but again, it was late last night, so. I guess it was just those three.
Let me know if you find the other one. If you page break issues, that'll, correct. If not, it's not a big deal. On page 43, take out the portion about defendant testifying.
Yeah.
And all on mobile. The defendant testifying, I'll take the heading. Closing argument instructions in the wrong place.
Yeah, I had a feeling it didn't really
Yeah.
make sense. I saw it in different places. That's what you had indicated, so.
right ahead of that instruction.
Judge, did you say that the, under the two paragraphs underneath defendant not testifying, that that would be unbolded?
Correct.
Yeah, that's what I thought you said.
And then I moved the closing argument instruction ahead of the general rules for deliberation. And that would be the break in the instructions before you give your closing arguments. And then after that, prior to the jury deliberating, I would start with these are some general rules that apply to your discussions and finish the instructions at that point, which is likely going to be tomorrow. Anybody spotted anything else?
I wanted to point out something that I did, make sure everybody is okay with. On count 4, which is the attempted first-degree murder counts that can be proven either by attempted premeditated, first-degree premeditated murder as well as attempted felony murder. Right. I was struggling a little bit with how to do that with the armed trespass, which would have been an unenumerated felony, so I treated it as a lesser included offense.
Right.
And I did it that way in the jury and the verdict form as well. That made the most sense to me. So I just wanted to point that out.
I noticed you did that when we talked yesterday as to whether it's a lesser included or whether it's just a sudden interrogatory. I think either way would be legally appropriate. Is there any objection, Mr. Wood, to the way that Mr. Johnson went about?
No, I read that over as well.
Okay. All right. Any other objections or exceptions to the jury instructions? Okay. We'll get those printed. More of our breaks. Let's talk about the verdict form. Take a look at that, Mr. Wood.
I did, Your Honor.
Any exceptions or objections or
No, Your Honor.
or anything like that?
No, sir, not that I've noticed.
Okay. That was painless this morning. I have a total of 46 pages of instructions right now, so I'll take about an hour to read them before your closing argument.
It's down from 62.
I greatly appreciate that, as the one who has to read them. All right, is there anything else we need to take up this morning before bringing the jury into commence with the defense case?
Yes, sir.
There it goes. Okay.
Defense provided for us a witness list for yesterday, for today. And just looking at the witness list, obviously we've, most of the, if not all the witnesses have been deposed in the case. And so we had kind of depositions to go from in terms of what to expect from their testimony. Some of those witnesses are the defendant's sisters, Rhonda Colley Boatwright, Crystal Wright, and then I guess a friend of the family's by the name of Tammy Folsom. A lot of, there's probably some things in there that I think are perfectly relevant from what we understand they might testify to, Judge. But we're concerned that there is a lot of information that they may attempt to testify to that is not admissible. I just was kind of going back through the depositions last night. There was a lot of efforts to bring up their knowledge of Amanda Colley's affair, things that they were aware of, not necessarily firsthand information, but things that they read, things that they were told about. For example, there's a lot of discussion about purchase of crotchless panties and lingerie, seeing website where they're looking at lesbian porn, things like that. I mean highly inflammatory stuff, Your Honor. And so I'm just greatly concerned that, and based on kind of what we've heard, opening statements and then various times during the course of the state's case in chief, that a lot of these witnesses are going to come in today basically to trash the character of Amanda Colley. Now, the story is what it is. That it's pretty clear from the evidence that the state has presented that Amanda Colley was seeing another individual, and that provided the motive for Mr. Colley to do what he did. But I think there's a danger of this getting to the point where it becomes a feature of the case, and we're talking about stuff that's not relevant, and we're talking about stuff that is going to wind up being based on hearsay and all of that kind of stuff, Judge, and improper character evidence. So I can't give you like a laundry list of what each person might say, but that's kind of a general concern that we have concerning some of the evidence and testimony they may give today.
Okay. I'm fully cognizant of the fact that the scope of discovery in a deposition is much broader than admissible evidence at trial, so there may have been things covered or discussed during the deposition that were not necessarily going to be elicited during trial. But Mr. Shoemaker, can you share with me some of your intended line of questioning with these folks as it pertains to character issues of the decedent, Ms. Colley?
Really, Your Honor, I don't think that anything I'm going to ask is going to come out that there's any character assassination of Amanda Colley or any of the other victims. The only thing I'm going to be trying to get from the witnesses are, what they observed leading up to the 27th.
What they observed of Mr. Colley?
Of Mr. Colley and Mrs. Colley, as far as, that they were having marital issues. I'm not going to get into anything about crotchless panties. I will say that the only place that does come up is I do have a line of text messages from the 24th, 25th, 26th that I was going to bring in through Detective Causey. And the only reason I'm bringing those in is because I think as far as the doctrine of completeness, the state has put in many texts from those exact dates, but they've cherry-picked what's good for them and left out the entire conversation, so it's hard to judge what was going on. So the only time anything of that sort comes up is conversations between Amanda and James via text message, and I'd be perfectly blunt with the court, there's just as much bad in there for James as there is for Ms. Colley. So, but as far as the witnesses, the sisters and Ms. Folsom, it's all going to be what they observed either the day of or the days leading up to.
See how some of that may be relevant in regards to the defendant's state of mind, with intent being one of the elements here. State of mind does come into play. Let me hear from the state on those text messages. Have you seen the text messages that the defense?
And Your Honor, yes, sir. That would be through my witness, Detective Causey. The state would object to the text message chain that the defense has provided. If you recall, Your Honor, we specifically introduced a narrow chain of text messages from August 24th that had to do with when he received the photograph of Lamar cutting the grass and then his immediate response to Ms. Colley. I did not introduce all of those text messages, but I introduced enough to show the context, and Detective Causey was asked, it's already been stated in there that in response to this questioning, Amanda was in fact denying the affair. I think that's so the entire context of the 24th has been put before the jury. The rest of what they're doing is on the 24th and on the 25th and the 26th, in which we did not introduce any text messages, is attempting to introduce conversations that are not relevant to motive, to anything to do with the homicide. It's self-serving hearsay in his text messages, and then obviously her responses would be hearsay back. It's more character type attempts to make her look bad, conversations they're having about the children and whatnot. And then again, I only introduced the limited thing about the photograph on the 24th and then the 27th. And Mr. Shoemaker is attempting to enter all of their conversations the 24th, 25th, and 26th, most of which have absolutely nothing to do, all of which, other than what's been already introduced and stated, have nothing to do with this homicide. So I don't believe the rule of completeness serves to make sure what one party has introduced has been served or introduced in context, and I believe we were not misleading in that, and in fact our witness testified as to sort of the crux of that conversation and Amanda's responses.
Doctrine of completeness is not a wide open door to allow for the admission of otherwise inadmissible evidence. Do you have copies?
Yeah, I could give you a copy. Yes.
Okay.
Yeah, I mean, we're objecting to the entire chain, absolutely. If you, you have to sort of pay attention to the dates, Your Honor. A bulk of them are the 24th, which, like I said, I believe the context of that conversation has already come in, the relevant portion. The 25th and the 26th has nothing to do with...
They might go over the 24th again, the same things that you introduced, have a problem with that.
Correct. There's a lot more, and that conversation kind of takes different turns, Your Honor, on the 24th, away from the photograph in Lamar. So.
Okay, we spent a few moments going through this, 10 pages or so. Mr. Colley, you can use the restroom while I'm reading through this, and I won't discuss anything with the lawyers until you get back. Appreciate your read through the text exchange. There's only one that I want to explore further. Lawyers. This is one from August 24, 2015 at 11:04:59. It's the second page of the pages that you gave me, Mr. Shoemaker. It's about 2/3 of the way down from Mr. Colley. This could be interpreted or viewed as a character assassination on the victim. It reads as follows. I'll read it into the record. By the way, let's add up what you've done over the last couple of months. Ordered a teddy and crotchless panties, Googled 4 sex positions that guaranteed orgasms, Googled best sex toys for couples, looked up lesbian porn, yeah, you haven't been sleeping with anyone, ... Why is that relevant?
Your Honor, I just left it in there due to the fact that I was putting in all the text messages. I agree it is inflaming and probably shouldn't be admissible, but I didn't want to take anything out before we get an opportunity to bring this up at the court.
Can you take that out with
I
a Sharpie
can,
or whatever?
I'm sure I could white it out or something and then recopy it if I could use some.
If you want to do that, just a Sharpie, and then I'll talk to the jury about if these items are edited, don't consider those things that have been edited out because they're relevant.
Yeah, I
However
can.
you want to go about it, so that we don't have delays.
Yeah, it won't take long.
Okay, so I will grant the state's oral motion in limine, and I'll conclude that one entry. Was there anything else the state saw that was particularly inflammatory? I didn't see anything particularly inflammatory. A lot of it's repetitive, but
Correct. As to the 24th, that would be the character type objection we were making earlier. But if you move to the 25th and the 26th, the objection would be just relevance. Relevance. I mean, they're not talking about anything related to the crimes at all. There's a situation where the children had come down with lice. So it's a back and forth about that on the 25th and the 26th, and I just don't see the relevance.
I'll overrule the rest of the objections, but I will sustain the objection as it pertains to that one text that we just talked about. Okay, anything else we need to take up this morning before we bring the jury in?
No, you're not. Yeah, and I just,
You mentioned 3 witnesses to me, Mr. Shoemaker, Rhonda Colley, Crystal Wright, Tammy Folsom.
Yes.
Detective Causey, I presume.
correct. And then we have a very quick Kyle Bedroom.
Sorry.
One
Did you
second.
want this back, Mr. Shoemaker?
Sure, yes. I
Yeah,
can go
that one, I'm excluding. With those 3 witnesses, do you anticipate you'll wrap up before lunch?
Yes, sir.
Okay. So I'll instruct the jury after lunch and then you start your closing arguments. Bring it back to deliberate tomorrow. Okay, so we're going
Yeah, I'll set that up.
It's almost done. Check this. Your Honor, may I run up and have your J.A. make a quick copy of that? I think it would hide it better. And, Your Honor, I've not seen Detective Colley. Can I run out and make sure he's here?
Sure, the jury's not here yet, so.
And I'll just go over that one.
You're ready for the jury.
Mr. Gray, be there in just a moment. Fine, Mr. Schmidt?
Yes, sir.
Good to go. All right, we can bring the jurors in. Welcome back, everybody. You all can be seated in the courtroom. Hope everybody had a good night. Welcome back. We are ready to continue in just a few moments. Let me just start off, as I do every morning, by just making sure that you all have not seen, read, or heard any media accounts of this case overnight. Is there anybody that did read or see or listen to any media accounts? So everybody shaking their head no. Okay, thank you, Mr. Legacy. Can I get a thumbs up? So- Okay. All right, we are ready to proceed. We are running ahead of schedule, so that's good news for everybody. It looks like I'll give this case to you all tomorrow morning, if all goes according to schedule, to begin your deliberations. And I'll have some instructions for you when we wrap up this afternoon for tomorrow morning. So when we left off yesterday, the state had rested its case. That's what we broke. And I began to work with the lawyers in the afternoon about finalizing the instructions that I'll give you to decide this case. So where we're going to pick up today is the defense is going to put on a case. As I mentioned to you at the beginning of the case, the defense is not obligated to prove anything. It's the state's burden of proof to prove the crimes charged. But the defense has chosen to put on a case. So at this point, we'll begin with the defense presentation of its witnesses. Mr. Shoemaker, you can call your first witness.
Yes, Your Honor, we call Detective Colley.
Detective Colley, you remain under oath. And if you'll take the witness stand, please. Mr. Shoemaker, you may proceed.
Yes. And I know you've been here a couple times already, but could you introduce yourself again?
My name is Detective David Colley. I work for the St. Johns County Sheriff's Office.
And again, just to recap, what were you asked to do as far as this case?
Perform extractions from, I believe, 5 cell phones in this case.
And was one of the phones, was that belonged to Amanda Colley?
Yes, sir, it did.
And do you know what the, let's say, the last 4 digits of that phone number was?
I'd have to look at my notes, but I believe I can come up with it.
Do you have it there?
Yes, sir, I do. If I may. 3603.
And then as far as James Colley, how was he listed in Amanda's phone number as far as contact?
He was listed as bitch in her phone, in his phone.
No, how was James listed?
Oh, JR, I believe.
There. All right.
I don't have any of those records.
Okay. May I approach, Your Honor?
You may.
I'm showing you what's been previously marked for defense identification purposes as Exhibit B. Do you recognize these?
Yes, sir, I do.
And what are they?
They would be text messages from Amanda Colley's phone.
And who was the conversation with?
James Colley.
All right. And did you have an opportunity to review these text messages?
I briefly looked over them, yes, sir.
All right. And are these a fair and accurate depiction of the conversation that took place between James Colley and Amanda Colley from August 24th of 2015 to August 26th, 2015?
As far as text messages, yes, sir.
Okay. Your Honor, at this time, I would move to introduce Defense Exhibit B into evidence as Defense Exhibit 1.
Any objection?
Just what previously noted, Your Honor.
As previously noted, okay. Now we received an evidence as Defense Exhibit 1.
All right, and how many, were there a number of text messages going back and forth?
There were several.
All right. And what I'd like you to do is you could start with the first one and read through as far as the conversation that was taking place.
Before we do that, folks, let me, because you'll have this with you when you deliberate your verdict in this case. There are edits in there to eliminate irrelevant matters. So when you go through it and you're looking at these items later, don't assume anything or draw any assumptions on those matters that have been edited because they don't pertain to this case.
And I'm sorry, were you done?
Okay.
Okay. And Mr. Colley, if you could, when it switches dates from, let's say, the 24th to the 25th, could you let us know that?
Sure. Could you repeat the actual first question?
Yes. Would you read the conversation that took place between Amanda Colley and James Colley starting on August 24th of 2015 at 9:32 and then finishing on August 26th?
Sure. This is I'm assuming to Amanda. Just know there are things that you could never take back. None of the kids call me why they've been gone and keeping them from his birthday party. You're a bad person. It's hard for me to, this is not a normal view I look at, so I'm not sure who sent what here.
Well, I believe
It doesn't say in and out box or sent or received or anything like that.
if you look at the top number, that's the sender, and or the name, that's the sender.
Okay. From James, Trey has his phone. He can call you anytime he wants. You could have called them anytime, but you never even bothered to check on them at all in 3 days. You always blame me for everything. You really need to start looking in the mirror. Very convenient that I don't hear one word from you about this until after the weekend. And I know you didn't work this weekend, but I bet this weekend, when it's your time with the kids you do, you're really a bad person, or really the bad person. Who is really the bad person? I'm sorry. The kids never asked to call you. I wanted to speak with them. Then if you want to speak with them, then you should have reached out. I don't have Trey's phone number. This is from Amanda, I'm assuming. I don't have the phone number, and I had no idea he even had a phone. The last time I received from you said, the last text I received from you said, don't mess with me and my family. No need to talk anymore. You can get the kids Monday. You told me not to contact you anymore. How was I supposed to get in touch with them? I did check on them every day through Facebook. I know you were with the at Adventure Landing Friday with our friends, I might add, and yesterday at the birthday party. I'm so sad I have to search Facebook to see my kids. I actually think those are messages to her from James, probably. But I have to back in a different report to see that.
Well, if you look at the next one, I think that clears it.
Yeah, okay, you're right. Amanda, you could have called for the kid. You could have called for the kids. I would never keep them from you. And just look at the call to check on, just like to call and check on them when they are with me. Just like you call and check on them when you're with me. The kids are one thing. I wasn't talking about that. You were mad about something a 5-year-old said. Grow up.
And then on the second page, it starts at the top with.
Trey wouldn't lie. And I know it. He lies all the time. 5-year-olds at the house have never gone outside to talk about the UPS man, I'm assuming, and wouldn't let him in outside, and wouldn't let him outside. Just stop. I didn't go outside to talk to him. He left the package at the front door. Trey went and got it when the lightning stopped, and he opened the package. This is BS, and you know it. It makes no sense. Just like you said, he is married, right? You're the biggest liar I've ever seen.
Detective Colley?
Yes.
When you start, can you identify who's talking as far as, let's say, James?
Sure.
Or Amanda?
That last one was from James. This is still from James. I'll just say when they change from one party to the next. Let's just speed this divorce up and get this over with. I really hope you live this person as destroyed our whole family for it. Love. It's from Amanda. You have seriously lost it. From James. Sure. Oh, and your boyfriend has been parking in the playground and walking around the back. The whole neighborhood knows. Or I'm assuming that's neighborhood. You should just have have him park out front like a man. Yeah, everyone knows. What are you? This is from Amanda. He is not my boyfriend, like I've told you before. He helps me with yard work, paint, moving furniture, etc. From James. So why isn't he pro in the driveway? If he isn't hiding? And I guess he is married, right? Amanda. What am I? Someone who finds it up to you and said enough is enough. No one should have to be spoken to the way you speak to me. James. Tell yourself what you want. By the way, he is ugly. I have a pic of him. From Amanda. He HD, whatever that means, parked in the driveway at the park to avoid this happening. How do you have a pic of him? You don't even know what you're talking about. From James. Sure. Were you going to cut the grass? Were you going to paint the bedroom, all the bedroom? Were you going to pick up the mattress for me? No, because you only care about yourself. And there's a picture from James of, it's hard to look at here, but it looks like it's the same picture of the man mowing the grass. Like I said, nice hair, LOL. And I'm sure he comes over to be a nice guy. And why does he? Like I said, everyone know what you are. This is from her. You have like 4 friends in the neighborhood, so don't try and act like what the Turskys or Dickens think is going to affect me. Again, from James. You still want to say you're not sleeping with someone, or try was lying, Trey. From Amanda. You've never liked Mike Dickens, and now you have him doing your dirty work. Trey was lying. I'm not sleeping with someone. James. Yes, you are. He isn't coming around for nothing, Amanda. Just stop lying. But I really feel you could do better than that. The top of this one's cut off.
Just move on to the next one.
Okay. That was from Amanda. I can't make what that one says. Next one from James. Don't worry, I will speak to him face to face sooner than later. From Amanda. He is my friend. I know that is a concept you know nothing about. From James. Good for you. From Amanda. I'm going for full custody with every other weekend going for you. don't trust your actions around them, so for now, your time should be limited. I'm going from James, I'm going for full custody as well. Don't be mad because you got doughy with your boyfriend. Just give me the fortitude I asked for and can move on. Then you can move him right on in. From Amanda, I'm not mad at all. I think you're ridiculous to jump to conclusions you know nothing about. From James, call me please. Excuse me. From Amanda, you caught me having someone mow the grass. Wow, I must be a whore. No. James, I don't want to fight. Can we just talk for a minute? From Amanda, no. From James, why are you mad at me? I have known this has been happening. I'm fine with it. I just want to work out the kids. From Amanda, because you're full of shit. You kept me from my son's birthday party and you're spreading rumors I'm a cheating whore. From James, I don't want full and neither do you. You know they need us both. Amanda, you are Amanda, you know you are more than friends. He's the fifth wheel, or he's fifth wheel. From Amanda, we are not more than friends, but keep sweeping lies about me. It just makes me hate you more. From James, call me please. Can I at least have the furniture? From James still. If you're with this man, just tell me so I can move on. I can't hurt you court because of Florida law. It can't hurt you court because of Florida law. I deserve the truth. But still from James, I can take that as a yes. From Amanda, I'm taking care of our children. I don't have any help, remember? I'm not with anyone. I'm trying to figure out what the rest of my life looks like. From James, well, I really hope that I can be in that picture. I love you. Still from James, kids okay, don't judge me. I just stopped at McDonald's. From Amanda, I just ate a bag of graham crackers. From James, yeah, but I don't have any kids with me. And graham crackers and a mule sounds freaking awesome. Still from James. Rhonda left for Italy today for 2 weeks. Tell the kids I love them and good night. From Amanda. Trey is asleep but still fighting with Avery. From James. Avery won't go down until after 11. Wouldn't go down until after 11 last night. Guess we wouldn't have that talk. I miss you. Still from James. Good night, love you. I'm sorry, correction, that was on that changed from the August 24th to August 25th. That last message, good night, I love you. From Amanda, good night. Do you think your dad can look at the AC tomorrow? From James, yes, text me in the AM so I don't forget, please. Also, don't forget about the letter and daycare. If I schedule more counseling for us, will you go? Turn up the air to 75 to like 75 before you leave so it doesn't have to work. Do hard, please. Your lady doctor for female stuff called me looking for you tomorrow for your tomorrow appointment. Is everything okay? From Amanda, yes, it's just annual. Correction, that switched to the 26th, back on, turn up the AC. From James, okay babe, just wanted to make sure everything was okay. Hope you have a good day. From Amanda, these are not in order because that goes back to the 25th. Back on August 25th, from Amanda, no lights for Trey, James Colley, thank God. That's a duplicate.
Sorry.
It's okay. From Amanda, this is still back on the 25th. We're here. From James, okay, I'm heading over. Is she okay? I'm sure she is scared. From Amanda, she is okay, sweet 1801. From James, okay.
Then it should go to 26.
It does. This is from Amanda. Do your parents get the kids okay? Don't forget the vacuum anywhere the kids were to make sure all the eggs are killed. James, they did. Be careful on your way home with you. Bad tried. Looks like it's going to storm. From Amanda. 95 is a mess. What are your parents soon with the kids? From Amanda still. Doing not soon. From Amanda. Op support senior manager. It looks like a hyperlink to maybe a job. I would have to search that and find out what that is. From James. You want me to find out more about you? I think it's an AML department. You okay? Air working? From Amanda. Migraine won't go away. Still laying with a rag on my head. I've been asleep since I got home, and I'm going back to sleep. I hope I'm not getting sick. From James, do you want me to bring you anything? I hope you're not. From Amanda, no, I just need to sleep it off. From James, okay, then we won't call you tonight if you want some rest. I love you and I hope you feel better. Please try to start forgiving me so we can move on. I really miss you and our family being together. Good night. Trey says he loves you too. From Amanda, hug them both for me. Good night. Will do. I know you love me still. It's okay if you won't tell me. Get some rest.
Is that the last text?
That's the last one.
1 second, Ryan.
Sure.
Karen, you have anything else?
Any cross-examination?
No, Your Honor.
Is Detective Colley excused?
I'd like to keep up just until the end.
You're still subject to recall.
May I approach, Your Honor?
That's okay. Mr. Shoemaker, you call next witness.
Kyle Bedran.
Mr. Bedran, if you could take a way to stand right here. I'll have you remain standing on the computer, and the clerk will administer the oath to you.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Be seated.
Thank you, sir.
Mr. Shoemaker, you can proceed.
Would you introduce yourself to the jury, please?
My name is Kyle Veteran.
And where are you employed, sir?
Right now I'm on law firm Veteran Law.
And is that local?
Yes, sir, it's in Jacksonville.
Back on August 27th of 2015, were you in the St. Johns County Courthouse?
Yes, sir, I was.
All right, and were you meeting a client there?
Yes, sir.
And who was that client?
James Colley.
Now, did James arrive on time? Was he late, or when did he get there?
To be honest, I don't recall exactly. I don't recall him being particularly on time.
Okay. All right, and when you arrived, did you have a conversation with Mr. Colley?
Yes, sir, I did.
Without getting into anything he said, what was his demeanor like?
He was very nervous. I guess a bit jittery would be the best way to describe him.
And did you take care of everything that needed to be done that day, as far as the appearance?
Yes, the appearance in the criminal case, correct.
Okay. And when you got done, did you have a conversation with Mr. Colley?
Yes, sir, I did.
All right, and was Mr. Colley, what was Mr. Colley's demeanor once you finished with the appearance?
Even afterwards, he was still a bit jittery, a little bit different than before, but still a bit jittery at that time.
Was he upset?
Based on my observations, I wouldn't say that he was necessarily upset.
Was he happy?
Again, based on my observations, I think I could say he was happy.
He was happy? All right, and did he do anything that was out of the ordinary that day? When you were finished?
When we were finished, dealing with these types of cases, we run into all different types of folks that when we're facing any courtroom for that matter, there's a bit of nerves that come involved. Based on my observations with Mr. Colley of our time at that, the jitteriness and I guess the nervousness that followed after we had resolved everything was a bit different than normal.
And when you left, when you departed, how did you say goodbye?
I believe Mr. Colley had given me a hug, shook my hand, and then we left, and I believe we were exiting out the south entrance.
And did you ever have any conversation with Mr. Colley again afterward?
No, sir.
I have 1 second. Sure. I don't have anything else at this time, Your Honor.
Okay. Any cross-examination, Mr. Johnson?
Good morning, Mr. President.
Good morning.
Just a few follow-up questions. When you met with the defendant the morning of August 27, 2015, when you had your conversation, I don't want to get into any of the conversations either, but when you had your conversations with him, did it involve, was he able to understand you, respond appropriately to whatever questions, whatever information you were providing to him?
Based on my observations, he didn't appear to misunderstand anything I was discussing with him.
Okay, he seemed to be coherent and in his right senses, so to speak.
As best as I could tell you, sir.
Okay. And Mr. Shoemaker was asking you about his demeanor, both during and after the court proceedings. You had indicated that he was jittery on both occasions, and then he asked you about whether he had appeared upset or was happy. When he asked you about whether he was happy, you kind of hesitated, and you said, "I could say he was happy." Is it fair to say that he wasn't like jumping for joy, he just was satisfied with the outcome of the proceedings that occurred that morning?
That's fair to say, yes, sir.
Okay. Thank you. Nothing further.
Can you redirect?
No, sir.
Mr. Drake, you are excused.
Thank you, Your Honor.
So you released from any subpoena?
Yes, sir.
Be subject to recall.
He might be subject to recall depending on what happens later.
Okay, you are subject to recall. Thank you. That's all we get to listen.
Your Honor, defense will call Rhonda Colley.
If you'll take the witness stand right here. You'll remain standing. Raise your right hand, please.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Take a seat.
Thank you.
Mr. Shoemaker, you can proceed.
So would you introduce yourself to the jury, please?
I'm Rhonda Colley Boatwright, James' sister.
And Ms. Colley, was James, or where was James living back in, let's say, early July of 2015?
He was back and forth between my house and his and Amanda's home.
Do you know when he first came to your house?
There were a couple times, July 4th for a few days, and then he went back home. And then I believe it was a Sunday, I think July 12th or 13th. I don't have the calendar in front of me, I'm sorry.
Do you recall if between the 5th and the 12th, whether or not you saw James and Amanda together?
Yes, several times.
And do you recall if Amanda was ever at your residence during that time frame?
I believe she was.
And how was your relationship with Amanda?
I would consider her one of my best friends.
And did you believe they were having marital issues at that time?
I knew they were, yes.
And what was your role, I guess, in the relationship?
I guess I was kind of like a go-between, in between the two of them. You know, I'm sorry. My brother was telling me they were having problems. He thought they were having an affair.
Calls for your son.
Sustained.
Don't get into anything that
Okay.
James may have told you, just what your role was as far as the relationship.
I was trying to get them to work it out.
Right. And at some point, did you become aware of the fact that there was an injunction in place?
I did.
Right. And when the injunction was in place, where was J.R. living with James?
He moved in with me.
And after the injunction, do you recall whether or not James and Amanda continued to see each other?
I'm going to object. I asked for a basis of knowledge.
Rephrase the question.
After the injunction, did you ever see James and Amanda together?
Yes.
All right. And was that frequent or how often?
I don't know what you consider frequent. I know it would be occasionally. When I was in Italy, I tried calling my brother. Trey's birthday was the 26th. So on the 25th, I called him. He didn't answer, so I FaceTimed Amanda to see if Trey would be with JR or Amanda. And she answered the phone. JR was with her. She was making them dinner.
And what day was that?
That was and I'm sorry, I think the 25th because, Italy's ahead. So.
And when did you go to Italy?
I left the Monday before. I believe that would be the 24th.
And what did you drive as far as a vehicle that night?
An Infiniti.
And what color was it?
Maroon.
Maroon. All right. As far as the vehicle, did you lock that vehicle up when you left to go to Italy?
I did.
All right. And what was the reason for locking it up?
I had 2 guns in the vehicle, and I wasn't planning on going to be home for several weeks. So we left, I think, Monday night. When I pulled in the driveway, we'd already packed the truck. My friends were already there and were driving with us to Orlando. They were waiting, my husband, my other friend who also was my housekeeper, dog watcher. She was out there. I gave her a key fob because I didn't want her to go with me to Italy and lose it, and asked her to put it up for me.
And what guns did you lock in the vehicle?
A 9mm, and I think it's a .45.
And where did those guns come from?
My brother and Amanda.
And why did you have those guns?
My brother husband had gotten me a .380 for Christmas, and the trigger I didn't like. I think it's called a double action trigger, but it was hard. So I was telling them that I had gone to the gun range, didn't like it, and he said try either one of these and see which one you like better, and then we can sell the .380.
And you may have stated before, but did you anticipate that anybody would be driving your vehicle when you went to Italy?
No, of course not. Nobody ever drove my vehicle.
And I wanted to back up a little. When you found out about the injunction, were you aware of I guess the parenting plan that was going on between Amanda and James?
Yes, I actually helped set it up.
And what was that?
Objection, relevance.
Sustained.
And I said, when James had the children, was Amanda involved in helping take care of the children?
No.
Objection, relevance.
What was your answer?
No, she was not.
When Amanda had the children, was JR involved in helping care for the children?
Yes. I would receive emails specific.
You can tell us what they say.
Okay. Yes.
All right. And how would he be involved? Would he go to school? Would he
He'd pick the kids up, he'd take them to football practice, he'd have dinner with them, they'd go to venture landing down the street as a family.
And again, without getting into anything that JR may have told you, you stated earlier that you knew that James and Amanda were having marital problems.
Mm-hmm.
Did you ever talk to him about that?
I did.
All right. And did you ever give him any words of advice or anything like that?
Objection, relevance, sustained.
I don't have anything else at this time.
Cross-examination, Mr. Johnson.
Good morning.
Good morning.
Is it Miss Colley Boatwright or just Boatwright?
Either one's fine.
Ms. Boatwright, I want to ask you a few questions, primarily about the guns.
Yes, sir.
You indicated that that you left the guns in your Burgundy Infiniti before you went to Italy,
That's correct.
and you locked the Infiniti because you had the guns in there. Is that correct?
Well, and I typically lock the car, yes.
Okay. But I think your answer to Mr. Shoemaker's question was that you locked the car because you knew you had the guns in there. Is that correct?
Because I typically had guns in my car.
Okay.
Yes.
And how long were you going to Italy for? Okay. Why did you lock the guns in the house?
Because I wasn't going into the house. I was running late, and I always carried one in the car, and then I had one in my purse. But when I was getting out, my purse was heavy, and I was like, oh crap, sorry. I was like, oh, I'm going through, security. I don't want to have this gun in the car, in my purse. And so I just stuck it down between the seat, hopped out of the car, and got into the truck.
Now, you and your husband, you had a gun safe at the time, correct?
No, not at the time.
Did you ever have a gun safe during the time that you owned these guns?
No.
Never? Okay. But you would agree that the guns would have been much more secure during your 2-week trip to Italy, to another country, if you had locked them in the house, correct?
I don't know if that's true or not.
You do have a lock on your house, right?
And I do have a lock in my car as well.
Okay, my question though is, you do have a lock on your house, correct?
Of course I do.
Okay. So you locked the guns in your car. You're going to Italy for 2 weeks. What type of guns did you say that you locked in your car?
9mm and a 45.
Okay, are you sure about that?
It was a 45. I think it was a 45.
Okay, you're sure about the fact that it was a 9mm and a 45?
I'm positive about the 9mm. I think I'm sorry, I'm not familiar with the difference between a 40 and 45, but I believe it was a 45, yes.
And you say that you got these guns from the defendant, is that correct?
From James and Amanda, yes.
And your testimony today is that he gave you both of the guns for you to try out because you didn't like the 380 that your husband had bought you, is that right?
Correct. I didn't like the trigger. It still needs to be triggered to this day.
Okay, my question though is, you have these guns because the defendant let you use them to see if you like them, correct?
Right, he was going to give me one,
You
correct?
didn't buy them from him.
No.
How long had you had the guns prior to your trip to Italy?
A few months, at
Did
least.
you have them in your car the entire time?
One of them, and the other one was in my purse with the house. Mine.
Now, do you know the brand or the maker of the 9mm and the 45 caliber gun that you're sure that you left in your car when you went on your 2-week trip to Italy?
I believe the 9mm was a Glock, but I'm not 100% positive, and I don't know the 45 for sure.
What color were the guns?
One was, I think, silver and one black. I can't remember. It's been 3 years.
Now, do you recall back right after these murders happened, Do you recall being interviewed about the guns in the car?
I was interviewed a year after the murders happened, yes, I do recall that. Are you referring to my deposition?
No, I'm not.
Okay.
I'm referring to an interview that you did with Sergeant Gene Tolbert on September the 14th of 2015, which was a couple of weeks after the murders. Do you
If you
recall that?
recall that interview, I actually went to go pick up items from the jail, and he asked me questions, and I told him I wasn't comfortable speaking with them without an attorney.
Okay, so, but you do remember talking to Sergeant Tolbert,
Yes.
and he asked you some questions. You actually volunteered some of that information, right?
I don't believe so.
And he asked, you had a conversation about the guns that you said that you left in your car. Is that right?
I don't remember.
Now, isn't it true, Ms. Boatwright, that at the time he was asking you which guns that you had in your vehicle, and you weren't really sure? Isn't that right?
I wasn't really even sure how I got home from Rome, so that doesn't surprise me that I wasn't really sure.
Okay, but that interview that occurred with Sergeant Tolbert was 2 weeks after the murders.
Right.
And
And since then, I've been through much counseling.
Okay, and today is 3 years since
Correct.
the murders, correct?
Yes, sir.
So your testimony here today is that your memory about the guns that you left locked in your car when you went on your 2-week trip to Italy is clearer 3 years after the fact versus 2 weeks after the fact. Is that correct?
Again, after much therapy, yes. I'm remembering more things.
In fact, you never even brought up with Detective Tolbert the fact that one of the guns you claimed that was in your car was a 9mm, did you?
I don't remember the conversation. I just remember, I mean, Ms. Johnson, I'm not trying to be difficult. I can just tell you, I remember going to the police station because they were supposed to bring my stuff back. I was picking up my laptop. I remember being locked in a room. And I don't even know if it was Detective Tolbert, and I couldn't tell you if it was or not. I remember a police officer coming in, asking me, wanting to talk to me saying I'm not comfortable really talking without an attorney present, and that's basically all I remember of the conversation. And I said, you remember Duke saying, why are you guys saying this is premeditation when you know that the guns were in my car? Something along those lines.
Right, you volunteered that. You're like, hey,
Right.
it's not what you guys think it is
Right.
because I had the guns in the car.
Right.
Right?
Yes,
And
sir.
he asked you, what guns did you have in your car?
Right.
And you said, I think it might have been a .45, but you said nothing about the 9mm, did you?
Right. I was on a lot of medication then too as well.
Okay. So you needed medication to be able to
This was a
answer his
very
question?
traumatic event. I know that a lot of people don't really care about the defendant's family, but we
Your Honor,
have
I
been
would
through
ask
this.
him, it's unresponsive, just answer Mr. Johnson's questions, please.
Can you repeat it again, please?
Now, when you're talking with Sergeant Tolbert, you had testified about this .380 that your husband bought you and you didn't really like.
Yes, sir.
Didn't you indicate to Detective Tolbert that the .380 might have been one of the guns that was in your car?
I do not recall the conversation.
Okay. So is it possible that you told him, indicated to him that your .380 may have been one of the guns in the car?
I don't recall the conversation.
Now, when you got the gun from your brother,
Yes, sir.
he gave you a case with it, right?
I think so, I'm not sure.
Okay. Do you remember what the case looked like?
No,
You don't?
no,
You don't remember what color it was?
I don't.
Do you know if it was a hard cover or soft cover?
I don't recall.
What happened with the case? Was it with the gun in the car?
I don't know because the car was kind of destroyed when it was brought back from
Okay.
Virginia.
Okay, that's not my question though. My question is, where was the case? He gave you the gun with the case, you said.
Right.
Where was the case?
I don't know. I don't know if I had it. I don't recall. It's been 3 years. I don't recall if I had left it on and when I took it out of my purse, if I stuck it down in the case. I don't remember.
Now, just last month, you testified at a hearing, correct?
Yes, that's correct.
Okay. And that was just a month ago, correct?
I believe so.
So when you gave your testimony a month ago at this hearing, were you thinking clearly then as you are today?
Again, I've been on medication. If you're referring, I said a 9mm in either 40 or 45 at that time.
Well, I'm going to ask the question. My question, though, right now is, were you thinking as clearly a month ago when you testified as you're thinking today?
Yes.
Okay, isn't it true that in that hearing a month ago, you testified that you thought it was a 9mm and a 40 caliber handgun that was in the car?
I said it could have been a 40 or 45.
Okay. Isn't it true, Ms. Colley, you don't really know? You're trying to keep track of all these guns, and you really have no idea about the caliber of these guns.
I don't believe that I agree with you on that.
Okay. So you don't know if it was a 380, at least back in 2015, it was a 380 or it was a 45?
I'm positive it wasn't the 380.
Okay, you're positive of that.
Because I didn't like the trigger on it.
Just like this morning when we started, you were positive that the guns you left in the car was a 45 and a 9mm, correct?
Again, I've been through much counseling since then, yes, sir.
Okay.
And
So we can't, everything that
this week.
So everything that you've said from the time that this event happened to today, you can't be trusted. But today, we can take your word that what you're telling this jury is the truth. Is that correct?
I'm not sure. I mean, I can't be trusted. I haven't changed my story.
Oh.
So I'm not sure what you're referring to.
Okay. Well, isn't it true you didn't tell Detective Tolber about the 9mm in 2015?
I was in shock. My brother was accused of murder.
So
I don't even remember how I got home. My friends had to pack my bag. I don't even remember if I flew into Jacksonville or Orlando. So I'm sorry if I wasn't very clear about my conversation with Detective Tolbert,
Okay.
but I was not.
all right. So, but today you're thinking clearly, correct?
Yes, again, I've been through much counseling since that time.
Okay. And today you're thinking clearly, correct?
That's correct.
All right. And you can tell, you're telling this jury that what you said today is the truth, correct?
Yes, I'm telling the truth.
And it's your testimony today that's not inconsistent with anything you've ever said before?
I don't believe that it is, no.
Okay. And you're telling this jury that you don't believe you left anything out before?
I don't believe so. Again, it would depend on what question you're asking me. I had a time block where I was in shock, and I don't recall things for several weeks.
Okay.
I was out of work. I was on disability. I mean, it was a very traumatic event for everybody involved.
Okay. So today you're telling us that you know for certain it was not a 380 handgun, is that correct?
That's correct.
And you're telling us today that you know for certain it was not a 40 caliber handgun, correct?
That's correct. I'm a little more informed about guns now, too, than I was then.
You've done some research on that?
We bought additional handguns, and so since then, yes.
Now, did you, when you kept these guns in your car, you didn't keep ammunition for the guns in your car, did you?
No, I had ammo and the guns.
Okay. You didn't like keep a box of ammunition in the front passenger seat, did you?
I did not.
You didn't like keep loose bullets rolling around in the front passenger seat, correct? You didn't have them anywhere in the car, did you?
No.
Did you, you didn't drive around with an AR-15 in your front passenger seat either, did you?
No, I did not.
Do you have an AR-15?
I do now.
Okay, that's not my question. My question is in 2015.
Oh, I'm sorry, I thought you said, do I have an AR-15?
In 2015,
Okay.
did you have an AR-15?
No, I did not.
Okay. Now, at the time all this happened, particularly when you gave your interview to Sergeant Tolbert, you really didn't know what had happened, correct? Exactly, correct?
In terms of?
The murders.
Correct.
Okay. You wasn't even sure
what guns were used to commit the murders, correct?
Yeah, it was all over the news.
Okay, my question is, were you aware of what they were? So you
Whatever was
heard
in
about it on the news. What did you hear on the news?
I just know that they were in the news
Okay, the fact that the murders had happened?
and protected guns were used and that he had fled, and I mean, those are things that were in the news.
So you had some information about that, is that right?
Yes.
Okay, and you've since learned, because the discovery process in criminal cases, you've since learned some more details about how the murders occurred, correct?
I don't know that I have.
Have you read any police reports in the case?
I don't know.
I'm sorry?
I don't think I have.
Have you talked to your brother about the case?
We talk, but we try to not talk about the case.
You talk to your brother a lot, don't you?
I do, daily.
Every day, several times a day, as a matter of fact, don't you?
Yes.
You love your brother, don't you?
Yes, and I love Amanda.
He's your little brother, right?
My baby brother, yes.
And you would do anything for him, wouldn't you?
Define anything.
Well, that's my question. You would do anything for your little brother, wouldn't you?
To a point.
Any redirect, Mr. Shoemaker?
Nothing, Your Honor.
This is both right excused.
Yes, sir.
Thank you, ma'am, you are excused. Mr. Shoemaker, call your next witness.
Tammy Folsom. Tammy Folsom.
Everybody in the junior high, everybody need a break. Okay. See, I'll get a lot of them, so we started some. If you'll take the way to stand right over here, please. You remain standing, please. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes. Thank you, ma'am. You can take a seat. Mr. Shoemaker, you may inquire.
Yes. Would you introduce yourself to the jury, please?
My name is Tammy Folsom.
Where do you live, ma'am?
I live in Baker County.
Do you sometimes stay in St. Johns County?
Yes.
And where would that be?
At the boat rides.
Okay.
At Dan and Rona Boat Rides house.
Okay. And would that be on back in 2015, would that have been on the Garrison Ave address?
Yes.
And did you do some work for them, or what's your relationship with them?
I did upkeep for the house. I did cleaning and watch dogs and watch the house while they were gone on trips.
And back in August of 2015, were you doing the same thing?
Yes.
Now, specifically back on August 27th of 2015, were you at the house that morning?
Yes.
All right. And tell me what your typical daily routine is. Get up, go to work, what do you do?
I'd get up and I'd take the dogs for a walk. I'd go and get a shower, and then I would head to work.
And what time do you usually get up?
At that time, I didn't have to be at work until 8, so I got up around 6:30.
And on that morning when you woke up, did you see James Colley at the residence?
Yes.
All right. And did you have any conversation? Well, what was he doing when you woke up?
The dogs made a noise, so I got up and I looked on the back porch because there was a glare or a glow. And I looked out and JR was out there on his phone playing some kind of game.
And at that point, did you have any conversations with Mr. Colley?
No, I went and laid back down, tried to sleep.
And then what time did you get up for work?
I couldn't sleep, so I went ahead and got up about 5:45. And then I let the dogs out back and said hello, good morning.
And did you, what was Mr. Colley doing at that point?
Still playing that game, smoking a cigarette.
Did you ever have, and I don't want to get into anything that he may have said, but did you ever have interaction with Mr. Colley?
That day?
That morning?
No.
All right, did you see him doing anything around the house?
No.
1 second. At some point, did you see Mr. Colley outside?
Yes.
And what was he doing?
I was leaving for work and he was cleaning his truck out.
And if you know, what was his demeanor at that time? Did he seem rushed? Did he seem angry?
No, he was just cleaning it out and he turned around and says, "Have a good day, Tim."
All right, did he act like his normal self at that point?
Yeah.
I don't have anything else, Sharon.
Cross-examination.
Yes, sure. Good morning, Ms. Folsom. You indicated that you upkeep the house and watch the dogs for the boat rides. Is that correct?
Correct.
Isn't it true that you're also very, very good family friends with Rhonda Colley and the family, correct?
Yes.
How long have you known Rhonda?
Since 2001.
And you've known James just almost about that long as well, correct?
Correct. He was laying some carpet at Citibank.
Okay. You characterize him as being like your brother in the
Yes.
past, correct? Okay. You indicated you stay at the boat rides house, including the one on Garrison. You do that quite often, is that right?
Correct.
You have family Sunday dinners with the family?
Yes.
You've been talking to the defendant since his arrest in this case?
Correct.
Visits and on the phone?
Yes.
So you're close with the family, right?
Yes.
Mr. Shoemaker asked you about the morning of the 27th, and I just kind of want to make sure I understand. You initially said you normally get up at 6:30, is that right?
At that time, yes.
Okay. But this occasion was different, correct?
Yes.
And what time did you initially get woken up that morning?
It was around 5:30. When I spoke to you at my deposition, I actually got the times wrong because I've been sick a couple of times, so I couldn't. I got kind of thrown off.
Okay. Tell me about it. So the first time you wake up that morning on the 27th is 5:30?
Correct.
And what do you see at 5:30?
I seen a glow on the back porch.
And you looked out, and is that when you said earlier you saw James on his phone?
Correct.
Okay. And then you're up. Are you up for good at that point?
Well, I wanted to lay back down, but I couldn't. And so I laid there for about 15 minutes, and then I just went ahead and got up and let the dogs out.
And then you saw him again prior to you leaving for work? Is that
Yes.
right? Is that when you said he was outside
Correct.
cleaning his truck?
Correct.
And that would have been approximately what time?
That would have been around, I would say about 6:30.
You said you had to be at work at 8?
Yes.
Okay. So you left at 6:30 to go to work?
Correct.
Where did you work?
At JA.
In Jacksonville?
Yes.
Ms. Folsom, do you recall testifying at deposition you referred to earlier? You recall that it was just a month or so ago? The deposition that we conducted about a month ago. Do you recall that?
I thought it was about a week or a week and a half, 2 weeks ago. It's just right before this started.
Okay, June 26th. A couple weeks ago now. Correct. You recall stating in that deposition that you woke up initially that morning at 4:30. Is that correct? You recall stating in that deposition that you knew it was actually 4:32 because you looked at your cell phone.
Correct.
Is that correct?
Yes. And like I said, I got the time wrong because I've been sick, so I was thrown off.
Okay. Do you recall in that deposition, you would also...
Judge, Your Honor, improper impeachment.
Let me hear the question.
Thank you. Prior to that deposition, Ms. Folsom, did you prepare a statement about your activities on the 27th?
Yes.
And you typed up a statement and handed it over to the defense?
Correct.
And that statement came up while we were in deposition as well, correct?
Correct.
And in that statement, you indicated that you woke up that morning at 4:32 and saw Mr. Colley, is that right?
Correct.
And that's a statement you typed up when?
It was after I got sick the first time. It was probably about a year ago. I'm not sure what day I gave it to him.
But a year or so prior to the deposition, when you typed it up, it said 4:30, correct?
Yes.
And not the deposition, just 2 weeks ago, you said 4:30, is that right?
Right.
And today here you're saying 5:30.
Right.
But both times you saw Mr. Colley, he was appeared fine, his demeanor?
Yes.
Okay. And he was on his phone when you saw him at 5:30 in the morning, is that correct?
Plain as can. Yes.
No further questions.
Any redirect examination, Mr. Schmidt?
No, Your Honor.
Ms. Wilson excused. You are excused, ma'am. Thank you. Mr. Shoemaker, how long do you think your next witness?
For me, probably only about 5 minutes.
Okay, go ahead and call your next witness.
Crystal Wright.
Ma'am, if you'll take the witness stand right over here. If you'll remain standing, please. Raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, ma'am. You can be seated. Mr. Shoemaker, you may inquire.
Would you introduce yourself to the jury, please?
Crystal Colley Wright.
And do you know James Colley?
I do.
And how is that?
He's my little brother.
And did you know Amanda Colley as well?
I did.
And how long did you know Amanda?
About 9 years.
All right. Back in, let's say, the summer of 2015, were you aware of the issues between James and Amanda?
Yes.
All right. And did you ever know about a time when James moved out?
Yes.
And once he had moved out, did you ever see the two of them together again?
I didn't see them together, but I know that they had been together prior to me entering the home.
Okay. All right, and what day are you talking about?
That would have been the 25th of August, 2015.
On the 25th?
Yes.
Okay. And what happened on the 25th?
I'm going to object. I think for a basis of knowledge is hearsay.
The question was what happened on the 25th, so without telling us what other people may have said to you, go ahead and explain what
No,
happened.
I was going to the home on Garrison Drive I was going to the home on Garrison Drive. 2 houses prior to the Garrison Drive home, Amanda had passed me, leaving the Garrison Drive home.
So you'd seen her while leaving the
Yes.
Is that Rhonda's?
Rhonda's home, yes.
Okay. All right, and is that the only time that you had seen them together since they moved out?
Yes.
And then also, as far as, did you see JR that day?
I did.
All right. And when did you see JR?
Within less than a minute, I pulled into the home. I had my child with me and I didn't want her to, so I asked my child to stay in the car and I went in, I confronted my brother and I asked him what she had been doing there.
And again, don't get into anything he said, but why did you confront him about that?
Because she wasn't supposed to have been there.
Sure.
I don't have anything else, Sean.
Cross-examination.
That was because he had an injunction against him, is that correct?
Yes. Filed by her, yes.
Right. To stay away from Amanda, correct?
Yes, and vice versa.
Any redirect?
No, you're not.
Ms. Wright, excused.
Yes, Your Honor.
Ms. Wright, you are excused. Thank you. Defense, call your next witness.
Your Honor, this time it was addressed.
Ladies and gentlemen, you heard the defense just rested its case. That's all the testimony you'll hear from the defense in their case. Chief, so I do need to meet with the lawyers for a little bit. The time is perfect for a mid-morning recess. It's 10:10, so it's going to take 30 minutes at this point since I need to spend a little time with the lawyers. I'll have you back, come back at 10:40. So at 10:40, be back in the lounge and be ready to come back. again, please don't discuss the case among yourselves during the break or with anybody else during the break. Don't do any research of any type. Leave your notes here in the courtroom when you sit here during the break. And we'll see you all back shortly. If you follow what Mr. Gray does.
The witness to make that decision, Judge, so the answer is possibly yes.
Okay. We should be in the process of moving the jury out. Are there any motions from the defense at this point?
Your Honor, I would just remove my previous motion for the judgment of acquittal.
That motion will be denied. How much time do you need, Mr. Johnson, to determine?
I believe we asked him to come on over, Judge, so if you give me maybe 15 minutes or so.
Okay. We'll come back at 10:40. I'll have the set of jury instructions ready to go at that point. I will hand them out at that point. If you have any rebuttal, then let me know. At the end of the rebuttal, I'll see the lawyers in sidebar, and we can address any motions at the close of all the evidence at that point again in sidebar. And then I anticipate instructing the jury this morning, and then we'll break for lunch, and then you all can give your closing arguments after lunch.
So you can kick that.
Exactly. Okay. All right, we'll be at recess until 10:40. Who's that?
Sergeant Gene Colbert.
Sergeant Tolbert. How long do you think that's going to take? Okay. But here's your 14. Better work out your utility for us for those. Casey, your insurance right. Probably should have stayed with your seven.
Thank you, sir.
Did the state prepare the dummy indictment overnight?
I apologize, Judge. I have not. I was going to do it at lunch. I don't know. Hopefully that's sufficient time.
That'll be fine.
I got so busy with other things.
Understood. Just
I
wanted to
have
remind
to make
you.
myself a note.
Okay.
Thank you, Judge.
Lunchtime will be fine. Is it going to be you all tomorrow, or is it Megan back tomorrow? Okay, so let me forget about it. Fish. If you're ready, go and bring the jury in. Back in. You all be seated in the courtroom. Chance to, welcome back. Everybody had a good break. We are ready to continue. As you recall, when break, the defense had rested. The state revised does intend to call the rebuttal witness. One witness. State, you can call your rebuttal witness.
State calls Sergeant Gene Colbert.
All right, Sergeant Tolbert, if you'll take the witness stand, you're taking under oath from earlier. Inquiring on the may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you just state your name for the record, sir?
Eugene Tolbert.
And you're a sergeant with the St. Johns County Sheriff's Office, correct?
Correct.
Sergeant Tolbert, I want to take you specifically to September the 14th of 2015. Do you remember meeting with Rhonda Colley Boatwright on that day?
I do.
And where did you meet with her?
In one of the interview rooms, we call it a soft interview room, has a couch and some toys in there for kids and stuff at the Criminal Investigations Division of the Sheriff's Office.
Okay, and what was the purpose of, how did that meeting come about? How was it arranged?
Rhonda had reached out to Detective English, inquiring about the return of some property that was seized during a search warrant at her home, 1189 Garrison Drive.
Okay, so this contact that you had with her on September 14, 2015, this was a contact that Rhonda Colley Boatwright actually initiated with your department, is that right?
Yes.
And you said that this occurred, you referred to it as a soft interview room?
Yes, sir.
Okay, and you said, can you kind of describe what we're talking about? Yeah, I know you said there was a couch in the room, but kind of, can you give a little bit further description of the room?
Yeah, we try to keep our interview rooms fairly sterile for, so we don't have a lot of distractions for suspects and things like that when we talk to them. But when we bring witnesses and family members, children in, this room is a little bit more warm. It's got some bright colors in it, some different furniture, some toys for kids, things like that. It's just a little, I guess, a little less offensive to some people. So,
is it a larger room than your other interview rooms?
that's probably about 7.
Okay. So when you met with her, it was you and her in this soft interview room?
Correct.
Okay. When you met with her, did you lock the door?
No, our door's not locked.
Okay. Did you stand in front of the door?
No.
Where was she positioned in reference to where you were positioned?
When you come into the room, there's a kind of a kitchen-style high-top table to the right. And then there's a full-size sofa that runs along the wall in front of the door. And then there's a couple of smaller chairs kind of to the right, just beyond where the table's at. And I was sitting in one of those chairs, and she was seated on the sofa.
Okay, so she was sitting closer to the door than you were?
Correct.
So, and you said the purpose of her initiating contact was that she was inquiring about the return of some property, is that correct?
Yes.
And this was property that had been taken from her home following the murders?
That's correct.
In reference to, with regard to a search warrant that had been done for her house, right?
Yes, sir, that's correct.
Okay. What specific property was she looking to have returned?
She inquired about some cell phones, some firearms, and a Apple computer.
Okay. During your conversation with Ms. Colley Boatwright about these items, did the subject of some guns being in a car come up?
It did.
And how did that conversation come up? Did you initiate that by asking questions, or how did it come up?
She kind of volunteered the information initially, and I kind of inquired further from there.
Okay. So she brought it up, and then you sort of followed up with questions after she initiated that conversation?
Correct. And I mean, I felt it was relevant at the time, being that firearms were found in her car in Virginia when Mr. Colley was taken into custody.
Okay. When you followed up with her, did you ask her about what kind of guns were in her car? And she, I said, let me back up and ask you, what did she tell you in terms of guns being in her car?
Your Honor, I'd object. Ms. Colley said she didn't remember, not that she did not make the statement.
Overruled. What did she tell you about guns being in her car?
She remembered 2 firearms being in her vehicle prior to her leaving to go to Europe.
Okay. Did she tell you what type of firearms were in her vehicle?
She said there were handguns.
Okay. Did she tell you what caliber of handguns?
She said she knew one of them was a .45, and she was pretty unsure on the other one, but she did mention possibility of a .380.
Okay. And did at any point in time during this conversation, did she ever tell you, either tell you clearly or even maybe even in an uncertain way, whether or not there was a 9mm handgun in her car when she left for a trip to Italy?
She did not say that, no.
Now, you said that early on she told you that there were 2 guns that she had left in her vehicle. Did that ever change in the course of your conversation with her?
Yeah, towards the end of the conversation, she kind of retracted a little bit and said that she thought maybe the .380 might have been put in her husband's truck at some point.
Okay, and there may have only been 1 firearm in her vehicle?
I don't recall she specifically said that, but that's what I got from it.
Okay. So the only 2 types of handguns that Ms. Colley Boatwright mentioned to you in terms of guns that were possibly in her vehicle when she left for a trip to Italy was .45 and a .380, is that correct?
Yes, correct.
And at some point in time during the interview, she indicated that she may have taken the .380 out and placed it in her husband's truck.
That's correct.
You also asked her about how she obtained the guns, correct?
Yes, I did.
And how did she say she obtained these 2 firearms that she claimed were in her vehicle?
The 380 she described to be a Christmas present, and she was fairly familiar with that firearm. She knew about the trigger and different things. And then the 45 she described that she had purchased from her brother, Mr. Colley.
Okay, the 380 you said was a Christmas present. Who, did she say who was a Christmas present from?
Memory serves me correctly, I believe she said her husband.
Okay. And the other firearm, she said she bought from her brother?
Correct.
Specifically bought. She didn't say that she borrowed it from him?
No, she said she purchased it.
Did she tell you that she got a case with the gun that she got from the defendant?
She did say she got a case with it.
And could she tell you what that case looked like?
She couldn't describe it in any detail. I asked her about colors and you know, any kind of characteristics to it, and she wasn't able to describe it.
Now, you also asked her about ammunition that was found in the defendant's bedroom at her house, correct?
Yes, sir, it did.
And did she, was she able to give you any indication as to who that ammunition belonged to?
No, she wasn't.
She didn't claim that the ammunition belonged to her, did she?
She did not.
And she didn't claim that it belonged to her husband, did she?
She did not.
Cross-examination.
Just quickly. It sounds like she was probably, she sounded a little unsure about what was in the vehicle. Is it a fair statement?
I think she wavered. I think that at times she came off very definitive, and at other times she was like, maybe I don't know. So, I mean, I don't know how you classify that.
So it went back and forth.
Yes.
She was sure, she wasn't sure.
Correct.
I don't have anything else from you.
Any reader? Is Sergeant Tolbert excused?
Yes, sir.
You are excused, sir.
Thank you, Judge.
Any further witnesses from the state?
Thank you, Your Honor. The state rests.
Okay, the state has rested its rebuttal case. I'll seek counsel at sidebar for just a moment. Excuse us, folks. Feel free to stand up if you like. Ladies and gentlemen, you've now heard all the evidence and testimony. In this case, all parties have closed and rested their case. The deputy right now is handing out to you the jury instructions. I'm going to instruct you on the law in just a moment. For scheduling purposes, let me tell you what we're going to do. I'm going to read these instructions to you. I am obligated by law to read the instructions to you, and you'll have a copy of those with you when you deliberate your verdict in this case. When I'm done reading the instructions, we're going to break for lunch. They're going to be kind of long, as you can see from the thick booklets being handed to you. Then we're going to break for lunch. When we come back from lunch, the attorneys will give you their closing arguments. That's going to take a couple hours. And then when they're done with their closing arguments, we'll break for the day. I'll have some instructions for you. When you come back in the morning, I'll have a few brief instructions for you, and then you'll deliberate your verdict starting tomorrow morning. So as you can see, this big packet is 46 pages. I'm going to read 43 of those pages to you right now. This, like I said, may take a while, and I may have to take some breaks along the way to get some water or something like that. But feel free to follow along if you desire to. And like I said, you will have a copy of these to take back with you when you deliberate your verdict in this case. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. James Terry Colley Jr., the defendant in this case, has been accused in the indictment with 2 counts of first-degree murder with a firearm, 2 counts of attempted first-degree murder with a firearm, 2 counts of burglary of a dwelling, and 1 count of aggravated stalking after injunction. I will now define those offenses for you. In counts 1 and 2 of the indictment, James Terry Colley Jr. is accused respectively of the first-degree murder of Amanda Colley and Lindy Dobbins. Each of these counts of first-degree murder includes the lesser crimes of second-degree murder, third-degree felony murder, and manslaughter, all of which are unlawful, and I will define those for you later. If in count 1 you find that Amanda Colley was killed by James Terry Colley Jr., you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, third-degree felony murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Likewise, in count 2, if you find that Lindy Dobbins was killed by James Terry Colley Jr., you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, third-degree felony murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The following instructions concerning excusable and justifiable homicide apply to both counts 1 and 2 of the indictment. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in a dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before James Terry Colley Jr. may be found guilty of first-degree murder as charged in count 1 of the indictment or any lesser included crime. There are 2 ways in which a person may be convicted of first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder as charged in count 1 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Amanda Colley is dead. 2, the death was caused by the criminal act of James Terry Colley Jr. And 3, there was a premeditated killing of Amanda Colley. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder as charged in count 1 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Amanda Colley is dead. 2, while engaged in the commission or attempted commission of a burglary, James Terry Colley Jr. caused the death of Amanda Colley. And 3, James Terry Colley Jr. was the person who actually killed Amanda Colley. In order to convict of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. The court will now instruct you concerning the definition of burglary as it applies to the crime of first-degree felony murder as charged in count 1 of the indictment. To prove the crime of burglary, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley, Jr. entered a structure owned by or in the possession of Amanda Colley. And 2, at the time of entering the structure, James Terry Colley, Jr. had the intent to commit an assault or battery in that structure. For other applicable instructions concerning the definition of the crime of burglary, the court refers you to those provided below as they relate to count 5 of the indictment. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of first-degree murder as charged in count 1 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of first-degree murder as charged in count 1 of the indictment are second-degree murder, third-degree felony murder, and manslaughter. I will now define those for you. To prove the lesser included crime of second-degree murder as it relates to count 1 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Amanda Colley is dead. 2, the death was caused by the criminal act of James Terry Colley, Jr. And 3, an unlawful killing of Amanda Colley by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that James Terry Colley, Jr. committed the lesser included crime of second-degree murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused great bodily harm or the death of Amanda Colley, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. If you find that James Terry Colley, Jr. committed the lesser included crime of second-degree murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that James Terry Colley, Jr. committed the lesser included crime of second-degree murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler, or firearm silencer, or any machine gun. To actually possess a firearm means that the defendant carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. To prove the lesser included crime of third-degree felony murder as it relates to count 1 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Amanda Colley is dead. 2, while engaged in the commission of an armed trespass in a structure, James Terry Colley, Jr. caused the death of Amanda Colley. And 3, James Terry Colley, Jr. was the person who actually killed Amanda Colley. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. The court will now instruct you concerning the definition of armed trespass in a structure as it applies to the lesser included crime of third-degree felony murder within count 1 of the indictment. To prove the crime of armed trespass in a structure, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. willfully entered or remained in a structure. 2, the structure was the lawful possession of Amanda Colley. 3, James Terry Colley Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Amanda Colley. And 4, during the trespass, James Terry Colley Jr. was armed with a firearm. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if under all the circumstances a reasonable person would believe that he had the permission of the owner or occupant. Person authorized means an owner or lessee, or his or her agent, or any law enforcement officer whose department has received written authorization from the owner or lessee, or his or her agent to communicate an order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally knowing. Can we silence that, please? Okay. Willfully means intentionally knowing and purposely. Structure means any building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. I have previously defined the term firearm for you. You should rely on that definition previously given. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime, he discharged a firearm, and in doing so caused great bodily harm or death to Amanda Colley, you should find the defendant guilty of third-degree felony murder with discharge of a firearm causing great bodily harm or death. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of third-degree felony murder with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of third-degree felony murder with actual possession of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of manslaughter as it relates to count 1 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, Amanda Colley is dead. 2, James Terry Colley Jr. intentionally committed an act or acts that caused the death of Amanda Colley, or the death of Amanda Colley was caused by the culpable negligence of James Terry Colley Jr. The defendant cannot be guilty of manslaughter by committing a merely negligent act or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death or an intent to commit an act that was not merely negligent, justified, or excusable and which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intent to harm the violation, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as it is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. If you find that James Terry Colley Jr. committed the lesser included crime of manslaughter as it relates to count 1 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he personally used a firearm, you should find him guilty of manslaughter with a firearm. I have previously defined the term firearm for you. You should rely on that definition previously given. If you find that James Terry Colley Jr. committed the lesser included crime of manslaughter, but you are not convinced beyond a reasonable doubt that he personally used a firearm, then you should find him guilty only of manslaughter. Now that concludes the definition of the offense in count 1 of the indictment and the lesser included crimes. I'll now move on to count 2 of the indictment. I now instruct you on the circumstances that must be proved before James Terry Colley Jr. may be found guilty of first-degree murder as charged in count 2 of the indictment or any lesser included crime. Like count 1, in count 2 of the indictment, there are 2 ways in which James Terry Colley Jr. may be convicted of first-degree murder. Again, one is known as first-degree premeditated murder, and the other is known as first-degree felony murder. I'll now define those for you. To prove the crime of first-degree premeditated murder as charged in count 2 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Lindy Dobbins is dead. 2, the death was caused by the criminal act of James Terry Colley Jr. And 3, there was a premeditated killing of Lindy Dobbins. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder as charged in count 2 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Lindy Dobbins is dead. 2, while engaged in the commission or attempted commission of a burglary, James Terry Colley Jr. caused the death of Lindy Dobbins. And 3, James Terry Colley Jr. was the person who actually killed Lindy Dobbins. In order to convict of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. The court will now instruct you concerning the definition of burglary as it applies to the crime of first-degree felony murder as charged in count 2 of the indictment. For the definition of burglary as it relates to this charge, the court refers you to those instructions provided to you previously in the first-degree felony murder portion of count 1. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of first-degree murder as charged in count 2 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of first-degree murder as charged in count 2 of the indictment are second-degree murder, third-degree felony murder, and manslaughter. And I will now define those for you. To prove the lesser included crime of second-degree murder as it relates to count 2 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Lindy Dobbins is dead. 2, the death was caused by the criminal act of James Terry Colley Jr. And 3, there was an unlawful killing of Lindy Dobbins by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that James Terry Colley Jr. committed the lesser included crime of second-degree murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm, or the death of Lindy Dobbins, you should find the defendant guilty of second-degree murder with discharge of a firearm causing great bodily harm or death. If you find that James Terry Colley Jr. committed the lesser included crime of second-degree murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of second-degree murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. I have previously defined firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of third-degree felony murder as it relates to count 2 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, Lindy Dobbins is dead. 2, while engaged in the commission of an armed trespass in a structure, James Terry Colley caused the death of Lindy Dobbins. And 3, James Terry Colley Jr. was the person who actually killed Lindy Dobbins. It is not necessary for the state to prove the killing was perpetrated with a design to effect death. The court will now instruct you concerning the definition of armed trespass in a structure as it applies to the lesser included crime of third-degree felony murder as it relates to count 2 of the indictment. I have previously instructed you on the definition and elements of armed trespass in a structure within the third-degree felony murder lesser included offense portion of count 1. You should refer to and rely on those instructions previously provided. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm or the death of Lindy Dobbins, you should find the defendant guilty of third-degree felony murder with discharge of a firearm causing great bodily harm or death. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of third-degree felony murder with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of third-degree felony murder as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of third-degree felony murder with actual possession of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of manslaughter as it relates to count 2 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, Lindy Dobbins is dead. 2, James Terry Colley Jr. intentionally committed an act or acts that caused the death of Lindy Dobbins, or the death of Lindy Dobbins was caused by the culpable negligence of James Terry Colley Jr. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm. If you find that James Terry Colley Jr. committed the lesser included crime of manslaughter as it relates to count 2 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he personally used a firearm, you should find him guilty of manslaughter with a firearm. I have previously defined the term firearm for you. You should rely on that definition previously given. If you find that James Terry Colley Jr. committed the lesser included crime of manslaughter, but you are not convinced beyond a reasonable doubt that he personally used a firearm, then you should find him guilty only of manslaughter. And that concludes the definition of count 2 of the indictment, including the lesser included offenses of count 2. I'll now move on to count 3. In counts 3 and 4 of the indictment, James Terry Colley Jr. is accused respectively of the attempted first-degree murder of Lamar Gubberly and Rachel Hendricks. Attempted first-degree murder as charged in count 3 of the indictment includes crimes of attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, and attempted battery, all of which are unlawful. Attempted first-degree murder as charged in count 4 of the indictment includes the lesser crimes of attempted second-degree murder, attempted felony murder, non-enumerated felony, attempted manslaughter by act, attempted aggravated battery, and attempted battery, all of which are unlawful, and I will define those for you later. If in count 3 you find that there was an attempted homicide of Lamar Gubberly by James Terry Colley Jr., you will then consider the circumstances surrounding the attempted homicide in deciding if it was attempted first-degree murder, attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, or attempted battery, or whether the attempted homicide was excusable or resulted from justifiable use of deadly force. If in count 4 you find there was an attempted homicide of Rachel Hendricks by James Terry Colley Jr., you will then consider the circumstances surrounding the attempted homicide in deciding if it was attempted first-degree murder, attempted second-degree murder, attempted felony murder, non-enumerated felony, attempted manslaughter by act, attempted aggravated battery or attempted battery, or whether the attempted homicide was excusable or resulted from justifiable use of deadly force. The following instructions concerning excusable and justifiable attempted homicide apply to both counts 3 and 4 of the indictment. An attempted homicide that is excusable or was committed by the use of justifiable use of deadly force is lawful. An attempted homicide is justifiable and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the attempted homicide. An attempted homicide is excusable and therefore lawful under any one of the three following circumstances. 1, when the attempted homicide is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the attempted homicide occurs by accident and misfortune in the heat of passion upon a sudden and sufficient provocation. Or 3, when the attempted homicide is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used, and the attempted killing is not done in a cruel and unusual manner. Again, dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I will now instruct you on the circumstances that must be proved in count 3 before the defendant may be found guilty of attempted first-degree murder, attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, or attempted battery. To prove the crime of attempted first-degree murder as charged in count 3 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. did some act intended to cause the death of Lamar Dubberly that went beyond just thinking or talking about it. 2, James Terry Colley Jr. acted with a premeditated design to kill Lamar Dubberly. And 3, the act would have resulted in the death of Lamar Dubberly, except that someone prevented James Terry Colley Jr. from killing Lamar Dubberly, or he failed to do so. A premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. If you find that James Terry Colley Jr. committed the crime of attempted first-degree murder in count 3 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted first-degree murder with discharge of a firearm. If you find that James Terry Colley Jr. committed attempted first-degree murder in count 3 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted first-degree murder with actual possession of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of attempted first-degree murder as charged in count 3 of the indictment, there may be crimes that he committed, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of attempted first-degree murder are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, and attempted battery. I'll now define each of those for you. To prove the lesser included crime of attempted second-degree murder as it relates to count 3 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. intentionally committed an act which would have resulted in the death of Lamar Dubberly, except that someone prevented James Terry Colley Jr. from killing Lamar Dubberly, or he failed to do so. 2, The act was imminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. Again, an act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. In determining whether the defendant is guilty of the lesser included crime of attempted second-degree murder, you are to consider whether the attempted homicide was either excusable or justifiable. For the instructions concerning the definition of excusable or justifiable attempted homicide, the court refers you to those provided previously. If you find that James Terry Colley Jr. committed the lesser included crime of attempted second-degree murder as it relates to count 3 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted second-degree murder with discharge of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of attempted manslaughter by act as it relates to count 3 of the indictment, the state must prove the following element beyond a reasonable doubt. James Terry Colley Jr. intentionally committed an act which would have resulted in the death of Lamar Dubberly, except that someone prevented James Terry Colley Jr. from killing Lamar Dubberly, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and use ordinary care towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In determining whether the defendant is guilty of the lesser included crime of attempted manslaughter by act, you are to consider whether the attempted homicide was either excusable or justifiable. For the instructions concerning the definition of excusable or justifiable attempted homicide, the court refers you to those previously provided. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an attempt to commit an act which would have caused death and was not justifiable or excusable homicide, as I have previously instructed you. If you find that James Terry Colley Jr. committed the lesser included crime of attempted manslaughter by act as it relates to count 3 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he personally used a firearm or a weapon, you should find him guilty of attempted manslaughter by act with a firearm or a weapon. I have previously defined the term firearm for you. You should rely on that definition previously given. Again, a weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted manslaughter by act, but you are not convinced beyond a reasonable doubt that he personally used a firearm or a weapon, then you should find him guilty only of attempted manslaughter by act. To prove the lesser included crime of attempted aggravated battery as it relates to count 3 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. did some act towards committing the crime of aggravated battery that went beyond just thinking or talking about it. 2, he would have committed the crime except that he failed. The completed crime of aggravated battery is defined as follows. 1, James Terry Colley Jr. intentionally touched or struck Lamar Dubberly against his will or intentionally caused bodily harm to Lamar Dubberly. And 2, in committing the battery, James Terry Colley used a deadly weapon. Again, a weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted aggravated battery as it relates to count 3 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted aggravated battery with discharge of a firearm. If you find that James Terry Colley Jr. committed attempted aggravated battery, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted aggravated battery with actual possession of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of attempted battery as it relates to count 3 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. did some act towards committing the crime of battery that went beyond just thinking or talking about it. And 2, he would have committed the crime except that he failed. The completed crime of battery is defined as follows. James Terry Colley intentionally touched or struck Lamar Dudley against his will, or James Terry Colley intentionally caused bodily harm to Lamar Dudley. That concludes the definition of the offense charged in count 3 of the indictment and the lesser included offenses. I'll now proceed on to count 4 of the indictment. As stated previously, in count 4 of the indictment, James Terry Colley Jr. is accused of the attempted first-degree murder of Rachel Hendricks. In count 4, there are 2 ways in which the defendant may be convicted of attempted first-degree murder. One is known as attempted first-degree premeditated murder, and the other is known as attempted felony murder enumerated felony, and I'll define that for you. To prove the crime of attempted first-degree premeditated murder as charged in count 4 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. did some act intended to cause the death of Rachel Hendricks that went beyond just thinking or talking about it. 2, James Terry Colley Jr. acted with a premeditated design to kill Rachel Hendricks. And 3, the act would have resulted in the death of Rachel Hendricks, except that someone prevented James Terry Colley Jr. from killing Rachel Hendricks, or he failed to do so. Again, a premeditated design to kill means that there was a conscious decision to kill. The decision must be present in the mind at the time the act was committed. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the act. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the act was committed. Again, the question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the attempted killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the attempted killing. If you find that James Terry Colley Jr. committed the crime of attempted first-degree premeditated murder as charged in count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted first-degree premeditated murder with discharge of a firearm. If you find that James Terry Colley Jr. committed attempted first-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted first-degree premeditated murder with actual possession of a firearm. I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the crime of attempted felony murder enumerated felony as charged in count 4 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. committed a burglary. 2, while engaged in the commission of the burglary, James Terry Colley Jr. committed an intentional act that is not an essential element of the crime of burglary. And 3, the intentional act could have but did not cause the death of Rachel Hendricks. For the definition of burglary as it relates to this charge, the court refers you to those instructions provided to you previously in the first-degree felony murder portions of counts 1 and 2. In order to convict the defendant of attempted felony murder, it is not necessary for the state to prove that James Terry Colley Jr. had a premeditated design or intent to kill. If you find that James Terry Colley Jr. committed the crime of attempted felony murder, enumerated felony, as charged in count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted felony murder, enumerated felony, with discharge of a firearm. If you find that James Terry Colley Jr. committed the crime of attempted felony murder, enumerated felony, as charged in count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted felony murder, enumerated felony, with actual possession of a firearm. Again, I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of attempted first-degree murder as charged in count 4 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of attempted first-degree murder, as charged in count 4 of the indictment, are attempted second-degree murder, attempted felony murder non-enumerated felony, attempted manslaughter by act, attempted aggravated battery, and attempted battery. I'll now define all of those for you. To prove the lesser included crime of attempted second-degree murder as it relates to count 4 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. intentionally committed an act which would have resulted in the death of Rachel Hendricks, except that someone prevented James Terry Colley Jr. from killing Rachel Hendricks or he failed to do so. And 2, the act was eminently dangerous to another and demonstrating a depraved mind without regard for human life. Again, an act includes a series of related actions arising from and performed pursuant to a single design or purpose. Again, an act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict the defendant of attempted second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. In determining whether the defendant is guilty of the lesser included crime of attempted second-degree murder as it relates to count 4 of the indictment, you are to consider whether the attempted homicide was either excusable or justifiable. For the instructions concerning the definitions of excusable or justifiable attempted homicide, the court refers you to those definitions previously provided. If you find that James Terry Colley Jr. committed the lesser included crime of attempted second-degree murder as it relates to count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted second-degree murder with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted second-degree murder as it relates to count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted second-degree murder with actual possession of a firearm. And again, I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of attempted felony murder, non-enumerated felony as it relates to count 4 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley committed an armed trespass in a structure. 2, while engaged in the commission of the armed trespass, James Terry Colley Jr. committed an intentional act that is not an essential element of the crime of trespass. And 3, the intentional act could have but did not cause the death of Rachel Hendricks. To prove the crime of armed trespass in a structure, the state must prove the following 3 elements beyond a reasonable doubt. It's actually 4 elements. 1, James Terry Colley Jr. willfully entered or remained in a structure. 2, the structure was in the lawful possession of Amanda Colley. 3, James Terry Colley Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Amanda Colley. And 4, during the trespass, James Terry Colley Jr. was armed with a firearm. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner or occupant. Person authorized means an owner or lessee or his or her agent or any law enforcement officer whose department has received written authorization from the owner or lessee or his or her agent to communicate in order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally, knowingly, and purposely. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. I have previously defined the term firearm for you. You should rely on that definition previously given. If you find that James Terry Colley Jr. committed the lesser included crime of attempted felony murder, non-enumerated felony as charged in count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted felony murder, non-enumerated felony with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted felony murder, non-enumerated felony as charged in count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted felony murder, non-enumerated felony with actual possession of a firearm. I have previously defined for you the terms firearm and actually possessed, and again, you should rely on those definitions previously given. To prove the lesser included crime of attempted manslaughter by act as it relates to count 4 of the indictment, the state must prove the following element beyond a reasonable doubt. James Terry Colley intentionally committed an act which would have resulted in the death of Rachel Hendricks, except that someone prevented James Terry Colley Jr. from killing Rachel Hendricks, or he failed to do so. However, the defendant cannot be guilty of attempted manslaughter by act by committing a merely negligent act. Every person has a duty to act reasonably and to use ordinary care towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. In determining whether the defendant is guilty of the lesser included crime of attempted manslaughter by act, you are to consider whether the attempted homicide was either excusable or justifiable. For the instructions concerning the definition of excusable or justifiable attempted homicide, the court again refers you to those previously provided. In order to convict of attempted manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act which would have caused death and was not justifiable or excusable attempted homicide, as I previously instructed you. If you find that James Terry Colley Jr. committed the lesser included crime of attempted manslaughter by act as it relates to count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he personally used a firearm or a weapon, you should find him guilty of attempted manslaughter by act with a firearm or weapon. Again, I have previously defined for you the terms firearm and weapon. You should rely on those definitions previously given. If you find that James Terry Colley Jr. committed the lesser included crime of attempted manslaughter by act as it relates to count 4 of the indictment, but you are not convinced beyond a reasonable doubt that he personally used a firearm or weapon, then you should find him guilty only of attempted manslaughter by act. To prove the lesser included crime of attempted aggravated battery as it relates to count 4 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley did some act towards committing the crime of aggravated battery that went beyond just thinking or talking about it. And 2, he would have committed the crime except that he failed. The completed crime of aggravated battery is defined as follows. 1, James Terry Colley Jr. intentionally touched or struck Rachel Hendricks against her will or intentionally caused bodily harm to Rachel Hendricks. And 2, in committing the battery, James Terry Colley Jr. used a deadly weapon. A weapon is a deadly weapon if it is used or threatened to be used in a way likely to produce death or great bodily harm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted aggravated battery as it relates to count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of attempted aggravated battery with discharge of a firearm. If you find that James Terry Colley Jr. committed the lesser included crime of attempted aggravated battery as it relates to count 4 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of attempted aggravated battery with actual possession of a firearm. Again, I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. To prove the lesser included crime of attempted battery as it relates to count 4 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. James Terry Colley Jr. did some act towards committing the crime of battery that went beyond just thinking or talking about it, and he would have committed the crime except that he failed. The completed crime of battery is defined as follows. 1, James Terry Colley Jr. intentionally touched or struck Rachel Hendricks against her will, or 2, James Terry Colley Jr. intentionally caused bodily harm to, and it should say Rachel Hendricks there because we're talking about count 4. And that now concludes the definition of the crime accused or alleged in count 4 and the lesser included offenses. I'll now move on to count 5 of the indictment. I will now instruct you on the circumstances that must be proved before James Terry Colley Jr. may be found guilty of burglary as charged in count 5 of the indictment or any lesser included crime. To prove the crime of burglary as charged in count 5 of the indictment, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. entered a structure owned by or in the possession of Amanda Colley, and 2, at the time of entering the structure, James Terry Colley Jr. had the intent to commit an assault or battery in that structure. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering of a structure is proved, if the evidence does not establish that it was done with the intent to commit an assault or battery, the defendant must be found not guilty of burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find James Terry Colley Jr. guilty of burglary as charged in count 5 of the indictment, you must also determine if the state has proved beyond a reasonable doubt whether in the course of committing the burglary, James Terry Colley Jr. assaulted any person. An assault is an intentional and unlawful threat, either by word or act, to do violence to another at a time when the defendant appeared to have the ability to carry out the threat, and his act created a well-founded fear in the other person that the violence was about to take place. If you find James Terry Colley Jr. guilty of burglary as charged in count 5 of the indictment, you must also determine if the state has proved beyond a reasonable doubt whether in the course of committing burglary, James Terry Colley Jr. battered any person. A battery is an actual and intentional touching or striking of another person against that person's will or the intentional causing of bodily harm to another person. If you find James Terry Colley Jr. guilty of burglary as charged in count 5 of the indictment, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. For purposes of burglary, a dwelling includes an attached porch or attached garage. If you find that James Terry Colley Jr. committed the crime of burglary as charged in count 5 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, and in doing so caused great bodily harm or the death of Amanda Colley or Lindy Dobbins, you should find the defendant guilty of burglary with discharge of a firearm causing great bodily harm or death. If you find that James Terry Colley Jr. committed the crime of burglary as charged in count 5 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of burglary with discharge of a firearm. If you find that James Terry Colley Jr. committed the crime of burglary as charged in count 5 of the indictment, and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of burglary with actual possession of a firearm. Again, I have previously defined for you the terms firearm and actually possess. You should rely on those definitions previously given. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of burglary as charged in count 5 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crime indicated in the definition of burglary as charged in count 5 of the indictment is trespass in a structure, which I'll now define for you. To prove the crime of trespass in a structure, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. willfully entered or remained in a structure. 2, the structure was the lawful possession of Amanda Colley. And 3, James Terry Colley Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Amanda Colley. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner or occupant. Again, willfully means intentionally, knowingly, and purposely. Again, structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find the defendant guilty of trespass in a structure, you must then determine whether the state proved beyond a reasonable doubt that the defendant was armed or armed himself with a firearm or other dangerous weapon during the trespass. I have previously defined for you the terms firearm and dangerous weapon. You should rely on those definitions previously given. And that concludes the definition of the crime alleged in count 5 of the indictment and the lesser included offense. I'll now move on to count 6 of the indictment. I now instruct you on the circumstances that must be proved before James Terry Colley may be found guilty of burglary as charged in count 6 of the indictment or any lesser included crime. To prove the crime of burglary as charged in count 6, the state must prove the following 2 elements beyond a reasonable doubt. 1, James Terry Colley Jr. entered a structure owned by or in the possession of Amanda Colley. And 2, at the time of entering the structure, James Terry Colley Jr. had the intent to commit a stalking, theft, or criminal mischief in that structure. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering of a structure is proved, if the evidence does not establish that it was done with the intent to commit a stalking, theft, or criminal mischief, the defendant must be found not guilty of burglary. Again, structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find James Terry Colley guilty of burglary as charged in count 6 of the indictment, You must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. And again, dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. For purposes of burglary, a dwelling includes an attached porch or attached garage. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of burglary as charged in count 6 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crime indicated in the definition of burglary as charged in count 6 of the indictment is trespass in a structure, and I'll define that for you. To prove the lesser included crime of trespass in a structure as it relates to count 6 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. willfully entered or remained in a structure. 2, the structure was in the lawful possession of Amanda Colley. And 3, James Terry Colley Jr.'s entering or remaining in the structure was without authorization, license, or invitation by Amanda Colley. Again, authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner or occupant. Again, willfully means intentionally, knowing, and purposely. And again, structure means any building of any kind, either temporary or permanent, that has a roof over it, and the enclosed space of ground and outbuildings immediately surrounding that structure. And that concludes the definition of the crime alleged in count 6 of the indictment, including the lesser included crime. And I'll now define for you the crime alleged in count 7 of the indictment. To prove the crime of aggravated stalking as charged in count 7 of the indictment, the state must prove the following 3 elements beyond a reasonable doubt. 1, James Terry Colley Jr. knowingly, willfully, maliciously, and repeatedly followed or harassed Amanda Colley. 2, at the time of the following or harassing, an injunction for protection against domestic violence had been entered against James Terry Colley Jr. for the benefit of Amanda Colley. And 3, James Terry Colley Jr. knew that the injunction had been entered against him. Harass means to engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. Course of conduct means a pattern of conduct composed of a series of acts over a period of time, however short, which evidences a continuity of purpose. The term does not include constitutionally protected activities such as picketing or other organized protests. Willfully means knowingly, intentionally, and purposely. Maliciously means wrongfully, intentionally, and without legal justification or excuse. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of aggravated stalking after injunction, as charged in count 7 of the indictment, there may be evidence that he committed other acts that would constitute lesser included crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crimes. The lesser crimes indicated in the definition of aggravated stalking after injunction, as charged in count 7 of the indictment, is stalking, which I'll now define for you. To prove the lesser included crime of stalking as it relates to count 7 of the indictment, the state must prove the following element beyond a reasonable doubt. James Terry Colley Jr. willfully, maliciously, and repeatedly followed or harassed Amanda Colley. The legal definitions of harassed, course of conduct, and willfully are provided above with the elements of the crime of aggravated stalking after injunction. That concludes the definition of all the crimes charged in the indictment, but I do have a few additional instructions for you. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilty. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted, as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witnesses. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusions about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. And you'll be glad to hear that concludes my instructions for you at this point. We're going to go ahead and break for lunch. When we get back, I'll give you that final one paragraph of instruction before the closing arguments, and then we'll get into the closing arguments. It is right now 10 minutes after 12, so I'll ask you to be back at 1:30. And as soon as we have everybody back, then we'll get you up here and we'll start with the closing arguments. Again, I don't have much of a voice left, but again, please do not discuss the case among yourselves or with anybody else during the break. Don't do any research of any type. Leave your notes here in the courtroom. They'll be protected.
as well as your jury instructions. Leave those with the notes. And then be back at 1:30 in jury lounge. As soon as you're back, we'll get started. Thank you, folks. Enjoy your lunch.